Welcome to Canadian Justice. I'm Christine Van Gyn, and today we are discussing consent and sexual assault. Please be advised that this episode could be upsetting for some viewers as it deals with sexual assault. The Supreme Court recently considered a case involving consent to sex on the condition of condom use. If a partner does not comply with a condition of condom use, is that sex then non-consensual? And does it constitute sexual assault? This act of not wearing a condom when your partner believes you are wearing one is sometimes referred to as stealthing, and it was recently confirmed by the Supreme Court as a form of sexual assault in a case called R. and Kirkpatrick. Here today to discuss this new Supreme Court decision and the issue of conditional consent to sex are two criminal lawyers, Sarah Leamon and Rachel Lichtman. Thank you both so much for joining me today. Rachel, let's start with the background of this case because it's a bit different from, I guess, what you call the standard definition of stealthing, if there is such a thing. The accused here didn't stealthily remove the condom in the middle of sex. He wore it, but only the first time. But when the couple had sex again the second time, a few hours later, he did not wear a condom. So what can you tell me about the important facts we need to know about this case?
So thank you for asking about the facts, because a lot of us are just talking about the legal principles, but the facts are actually quite interesting here. So basically, a guy and a girl met on a dating app, and then they met up to discuss the possibility of having sex. And at that first meeting, the female, the complainant, made it very clear that she only has sex with a condom, that that's very important to her, that that's the only way that she thinks it's safe. The male, the accused, was saying that he didn't really care for condoms, but he agreed that it was the safest way to have sex. They then met up to have sex. And the first time they had sex, she saw the male go to his nightstand, take a condom out. It was dark in the room. She couldn't see exactly what was happening, but she did hear the wrapper and she did see the motions of what would be the male putting a condom on himself. And so they had intercourse, and during the time of while they were having intercourse, he specifically asked her, "Where can I ejaculate?" Meaning he was going to take off the condom and ejaculate somewhere on her. And she said, "Anywhere besides for my vagina or buttocks." And I think that went even more so to her point about this idea of safe sex, that she doesn't want any of his bodily fluids touching sensitive places of her body. And so they finished having sex the first time, and she was so caught up in this idea of condom use, she even asked him after they completed the sexual act, like, "Can you show me the condom?" And he did. And it was satisfactory to her. She said that it had looked like it was used. And then they had sex the second time. And that second time, the sex started off with her on her stomach, so she couldn't see the accused person. And then she turned around and she was facing him. And there was even a time during the act of sex where his penis came out of her and he asked her to put it back inside of her, and she did. And then he eventually ejaculates inside of her. And that's when, according to her testimony, she realizes he's not wearing a condom, and she really freaks out. And she says to him, like, what about if I get pregnant? What about different STIs or STDs? And he tells her, "Oh, you can get an abortion and don't worry about it. Like, people can live with AIDS now. People can live with gonorrhea and chlamydia. It's fine." And she's so upset that she texts him later on saying, "How could you have done that? I can't believe you did that." And the way he responds, I think, is very indicative of this person's behavior. He sends her links to porn videos that have the title like something like "Daddy," and then says offers to her with his friends. So those are the facts. And I think that that's something that we should always keep in mind when we're talking about this case and what the Supreme Court of Canada ruled here.
Yeah, well, it's pretty intense. Sarah, the same question. Is there anything that you want to add to the background here? We've got about a minute.
Yeah, I think that was a very thorough analysis of the facts, and I don't have a lot really to add, but or perhaps to say that there was some indication in the facts that the complainant had actually observed this person having leaned over towards that same bedside table where he had gotten the first condom on the first occasion. So there was some discussion about how that could have been purposefully deceiving.
Right. Okay. Because, yeah, it was the first time it seemed like he wore it and she was satisfied he had worn it. The second time she thought that he was wearing it. And Sarah, how much time had passed between the first and the second time? We've only got about 10 seconds. Do you know?
My understanding is that it was just mere hours. Like
Right.
it was once at night and then once in the morning again.
Right. Okay. We've got to go to commercial break now, but we will come back and discuss what the Supreme Court held in this case. This Supreme Court case, R.N. Kirkpatrick, Sarah, the Supreme Court has ruled on this issue. What have they decided?
What they decided to say here is that essentially the fraud analysis doesn't apply in a case here where there's condom use, so non-consensual, non-condom use. Instead, what they're saying is that it essentially nullifies any consent to the sexual activity in question, rather than having to apply a fraud analysis and have to prove that there was some attempt to deceive, as well as some potential deprivation on the part of the complainant. They've applied a much more straightforward test. And I think that that's quite welcome for many different people in the community, as well as organizations. And even from a legal perspective, it tends to make things a little bit less complicated.
So, Rachel, anything you want to add about the Supreme Court's finding here? And kind of as the takeaway, does this mean that if your partner asks you to wear a condom and you don't, or you take it off, is that now sexual assault?
It is definitely sexual assault. And that is the takeaway exactly, Christine. And I think it's a great takeaway. I think that it very much is a very different sexual act if you're having sex with a condom versus without a condom. And that's exactly what the Supreme Court ruled, that if someone consents to having sex with a condom, and if then someone takes it off or doesn't respect that wish, that is sexual assault, because that behavior goes to the heart of what the person did or did not consent to.
Sarah, what happens next for the accused here, Kirkpatrick? The court has said they haven't decided on his, guilt or whether he should be acquitted. They've sent it back for a new trial. So why is that?
That's right. So I expect that this will proceed to a new trial. Essentially, the court has held that we need to have a new trial here so that we can properly analyze the issues at play and make sure that the law is being properly applied. It will be, of course, at Crown discretion as to whether or not to continue to proceed, given a number of factors, including the passage of time. But I expect that this matter will find itself before the courts again.
So, Rachel, in this case, the accused, as we discussed, wore a condom the first time, but not the second. And obviously, as we discussed, the amount of time that had passed in that case between the first and second time was not very long. It was a few hours. And the court found that there was evidence that the complainant did not consent to the sexual activity in question there, condomless sex. But how would that principle apply going forward? It's sort of like a one-time assertion of a condom condition always stand? Is it a condition every time until the requesting partner expressly says it's no longer required? Does it need to be reasserted, or is it just a standing condition then?
So I think that's a great question. I think the fact that now the Supreme Court has said that condom use and not condom use, that's an essential aspect of a sexual activity. That is a sexual activity and that needs to be consented to. I think now the standard that we have to go to is a standard of Barton, where the Supreme Court held what consent means. And they said it doesn't matter what the relationship is between the two people. It doesn't matter if you think that there's implied consent, there isn't. Every time that two people engage in sexual activity, there has to be communicated affirmative consent. And that goes for condom use as well. If you're okay with someone not using a condom, or if you want to ask someone if they're okay with not using a condom, that has to be specifically communicated in the affirmative. Someone can't say, well, there was not really any mention of it, or I didn't think this, or some time had passed and maybe the second time they didn't care to. No, I think now that there's been a ruling that it does form part of the sexual act itself, there has to be that express communicated consent that I'm okay with having sex without a condom. Absent that, it's not okay.
Sarah, does the level of sort of assertiveness about how clearly this complainant in this case was so explicit in her desire to have a condom, does that matter at all? Does a more casual assertion of I'd prefer if you use a condom, is that the same value, or is it identical, or is it different at all? She was very insistent in this case.
Yes, absolutely. And I do think that that helped the court in reaching their decisions here where we didn't have previous jurisprudence on the issue, really. I echo many of the things that Rachel has expressed here. I think that, it is something that is going to now play into the analysis about the type of sexual activity, the quality of the sexual activity in terms of what that is and what it entails, which goes to issues of consent. Now, perhaps we can have accused people mount a defense of honest but mistaken belief in consent.
Sarah, we've got to go to break, but we'll be right back. Now, Sarah, there is existing case law in Canada on condom use and consent. It involves a case called Hutchinson from the Supreme Court. And in that case, the question was whether there was fraud in obtaining consent. It was an analysis that was considered in this case as well. But Hutchinson was different because it was a case involved the accused who had poked holes in a condom. So how did that apply in this case, and did it apply?
That's right. So in Hutchinson, the issue was that there was tampering with the condom. And so a fraud analysis was used there, which had to show that the accused person, first of all, meant to deceive the complainant by tampering with the condom. And secondly, that there was some deprivation or risk of deprivation. And so that is a more onerous legal test than what was ultimately applied in Kirkpatrick. So it is distinguishable. Hutchinson analysis will still be used. The Kirkpatrick decision, in my view, does not invalidate Hutchinson. In fact, we're going to have two of these decisions now existing simultaneously side by side.
You know, Rachel, one of the things I don't quite understand in differentiating these two cases is how tampering with a condom can be fundamentally different, which the Supreme Court seems to have said, how it's different from just not wearing one, because they can both result in the same thing, which is increased risk of a sexually transmitted infection and an increased risk of pregnancy. So how did the court distinguish these?
For sure. And I guess that's something that I was also working with in my head. The effect of sabotaging a condom and not wearing a condom are really, it's the same risk that you're putting yourself into that pool of. But the difference that the Supreme Court ruled here was that the actual act of sex itself is different when you're wearing condom and not wearing condom. And that's because there's indirect versus direct contact. So it totally changes what the actual physical experience is and what the actual sexual act itself is. While poking holes in a condom, you're still actually wearing a condom. There's still indirect contact. It's just that now that the condom is sabotaged, so there's different effects that can happen because of that.
Now, there was also a dissent in this case, Rachel. The dissent, or I guess it was the same result, but which was a new trial, but for different reasons. So I'm not sure if that's correctly called a dissent or a concurrence in this case, but certainly they were critical of the majority's thinking. And they said that Kirkpatrick should get a new trial, but they said that the principles from Hutchinson should be applied. The fraud test should apply. So can you elaborate on that a little bit?
Sure. So they said it was basically, it's the same thing, that we're talking about the same thing. When you're talking about wearing condom or not wearing condom, or whether the condom was sabotaged or not, that's the same test, and that Hutchinson should apply, that Hutchinson thought of this idea. It's a broad framework that should apply. And they went through the different ways in which you can overturn a Supreme Court decision and said you can't. The thing is, the majority, so to speak, or the decision that was followed, they weren't saying that Hutchinson should be overturned. They were just saying that this case is different because in Hutchinson, someone was wearing a condom and here they weren't. And another thing that the Supreme Court brought up here was that if the timing of it all. So if someone realizes that a condom is sabotaged while the sexual act is happening, they then have the power to revoke their consent. So then the test that's laid out here in Kirkpatrick would apply, and it would be a part of the sexual act itself, as opposed to a second test of whether there's fraud or not, which is what Hutchinson talks about.
A lot of nuance here. Sarah, I want to acknowledge how disturbing this practice is. A lot of our viewers probably did not know what stealthing was before watching this, and I'm sorry to have to inform them of it. But do you have any information on how common this practice is? I've read that it is a new phenomenon, but what more can people know about this?
Well, in my experience as a defense lawyer here, it is something that I am familiar with. Unfortunately, people who've been charged with this type of activity here in British Columbia that I'm personally aware of. So this is not unusual. I'm also aware that there is, online communities that discuss, particular stealthing techniques or tactics that can be used. And in my view, stealthing comes down to the power dynamic that comes inherent with all sexual assault, where people are, not trying to maybe, have risky sex, but just simply to engage in this in this imbalance of power and to feel powerful as a result of it.
I think it's a mistake to think it's all about, physical sensation, because I think to me it seems about just not having a partner, not respecting your partner's wishes and wanting to do what you want, which is what sexual assault's about. We'll be right back. Welcome back to Canadian Justice, where we are discussing the law of condom use and consent and sexual assault. Please keep in mind that this topic can be upsetting for some viewers. Rachel, the Supreme Court in this case noted that this is a type of crime that disproportionately affects women. So what can you tell me about that and why it matters in this case?
I think just based on the facts itself, it disproportionately affects women. We're talking about men that are removing condoms in the middle of sex when women are saying, I'm only going to agree to have sex with you if you wear a condom. So it's the woman's wish that's being completely disregarded. It's also the woman that risks getting pregnant. It's her body that undergoes all of that, and she bears that burden for the 9 months, as well as, whatever she decides to do after. Or if she decides to get an abortion, she also bears that burden. So it definitely affects women a lot more. They have to be the ones to live with the consequences of what's happened. And if you're going to make a decision on this subject, on a subject that does disproportionately affect women more, if you're going to make a decision that affects them negatively, then yeah, you're hurting women more than you're hurting men if this crime hurts women more than men.
Sarah, this case was about the issue of consent and condom use. And the court focused on how it's crucial because it's part of the sexual activity. It was about condom use, but what else could fall under that category as fundamental to the sexual activity? Is that kind of an open category, or does it only apply to condom removal? Could it apply to something like the use of birth control pills? If a partner makes a verbal promise if a woman makes a verbal promise to her partner that she's on oral birth control and it's not true, what would the Kirkpatrick analysis apply? Because that's crucial to the act. Or would that be under the Hutchinson framework where that could be fraud? What do we need to know about that?
Yeah, I think this is a great question. And I think it's one of the big questions that a lot of people had when this decision came out. What else can apply? In my view, I think that it would be most appropriate to use a fraud analysis, so the Hutchinson analysis, in a case of, say, oral contraception misuse or misrepresentation, for example, because it's not qualitatively part of the sexual act itself, but perhaps a condition that one party has imposed that has been disregarded.
Rachel, anything you want to add to that?
Yeah, I would just say, what Sarah just said, that when you are taking birth control pill or not taking birth control pill, it does not go to the specific sexual physical act itself. However, it can, with if someone's taking it or not taking it, their chances of getting pregnant changes, and that can go to the idea of serious bodily harm. And the courts have been clear that a possible pregnancy is something that would be considered serious bodily harm.
But would that apply if say, the woman has lied about taking birth control? Because the physical harm of pregnancy, which can be a dangerous condition, that would apply to the woman. But what if she had told, given this misrepresentation to her partner who's male or female?
I think it can be still very much a physical and a sexual assault on a man if a woman says, I'm on birth control and she's not. Because if we talk about serious bodily harm, it's in a lot of different ways. I think stealing someone's bodily fluids to use them to create a child when that person's not consenting to it, I think that's very serious bodily harm. So in my opinion, 110%, a woman can be found guilty of sexual assault by fraud, vitiating consent, canceling out the consent if she says, I'm on birth control and she's not.
Certainly disturbing. Although I don't know if there have been cases about that, that type of thing. Sarah, there are some jurisdictions that have expressly put in the criminal code that this is an offense, this surreptitious condom removal, like California. Do you think that would help in Canada, or is this common law standard enough?
In my view, the common law standard is probably good enough, at least for now. I'm not a huge fan of codifying every single thing in response to these types of novel cases. I think that we have binding case law now, and we have a very clear indication of the state of the law from the Supreme Court of Canada.
Well, Sarah Leamon, Rachel Lichtman, thank you so much for coming on and sharing your expertise.
Thank you.
Thank you.
We've heard today about the disturbing new trend of stealthing, non-consensual condom removal during or before sex. This is a disgusting practice that should be condemned by society because it disrespects and objectifies the person requesting condom use. And now the Supreme Court has held that stealthing is worthy not only of moral condemnation, but also of criminal sanction as sexual assault. Thanks for watching, and remember, a freer Canada starts with you.